Okay, so good morning, everyone. My name's Margot Bennett. I'm the Executive Director of Women Against Gun Violence. And I want to welcome you to our very first webinar. And this one is on California's high capacity magazine ban and its current status as a... I'm okay. Somebody called in and they weren't on mute. So, okay, we're ready to go. And so, so this is our first webinar, and I just want to mention a few things. So this is our first time hosting a webinar, and we hope there won't be any glitches. Of course, we just had a minor one. And so to be realistic, it's highly unlikely that we will be glitch-free. So in advance, I'd like to ask you for and thank you for your patience with us. Second, we will be taking questions via Q&A at the end of the presentation, and we'll also try to reach out to you via email if we don't address your question during the webinar. So on your Zoom screen, you will have the ability to type out and send us a question. I want to thank Mary Kopp with Hope and Heal Fund and Steve Lindley, who are both helping us with their technology expertise. And I want to thank Norm Dupont, our board member, who conceived of this teach-in webinar and who is participating. And so now I want to take a moment to introduce you to Women Against Gun Violence. Steve, may I have the next slide? Okay, so for those of you who don't know us, we've been around for more than 25 years. Our focus has been really to shift popular cultural views on firearms, and shifting those views has allowed us to help pass strong and effective gun laws and come up with programs that have been very well received on gun safety. Next slide. And so our first speaker will be Steve Lindley, who is with Brady. He has a 27-year law enforcement career, including working for the National City Police Department in San Diego County and for the California Department of Justice. He's served as the chief of the Bureau of Firearms for more than 8 years, during which he testified in over 80 firearm-related legislative hearings, collaborated in more than 100 firearm-related bills, and assisted in authoring and implementing California's landmark ammunition background check initiative, which maybe he can take a moment later and update us on the status of a recent court ruling. Next slide. Thank you. And then we have Norm Dupont, who is a board member with Women Against Gun Violence. In his role as an attorney, he has helped us with many of our projects that deal with legal issues on gun control and violence, and has helped draft ordinances at the local level to limit gun possession and ensure safe use of guns. So with that introduction, I am now going to turn our webinar over to Steve Lindley.
Thank you, Margot, and again, thank you for asking me to be here today to talk a little bit about high-capacity magazines. So to start off with, kind of what are they and why should we care about high-capacity magazines? And at least here in California, high-capacity magazines kind of have a long history of both legislation and litigation, and we'll talk a little bit about the effects of it, because a lot of individuals will talk that a ban on high capacity magazines, ban on assault weapons, background checks don't make an effect on crime. And I think we're going to talk about that it actually does. So first off, what is a high capacity magazine? So under California Penal Code section 16740, a large capacity magazine means any ammunition feeding device with a capacity to accept more than 10 rounds, but shall not be construed to include any of the following. So a feeding device that has been permanently altered, a 22 caliber tube ammunition feeding device, or tubular magazine with a lever action rifle. So what does that all mean? That is the typical, sorry, Norm, a lawyer legalese about trying to define a particular issue. So, whether you're a layperson or maybe a law enforcement officer or, legislator or an attorney, it kind of means different things. But essentially, a firearm high capacity magazine is some type of device or mechanism that feeds bullets into the firearm, and it holds more than 10 rounds. So it can be external, it can be internal, except for a tubular magazine. And I'll give you a couple examples here in a minute so we can take a look at what those are. It does not have to be removable. So a lot of people ask, why are 22 caliber firearms, especially with a tubular magazine, exempt from this? So in order for the legislators to sometimes get laws passed, they have to make compromises. And one of the compromises oftentimes is with 22 caliber firearms, because everyone brings up, oh, I used a 22 caliber rifle when I was 10 years old, learning how to learn how to fire a firearm. I used that when I was in the Girl Scouts or the Boy Scouts. There's a ton of them there, and they don't, a lot of people don't believe that they are a deadly round, which is actually in contrast to what the ATF shows with their firearm trace data, is that a 22 caliber firearm is either the second or the first most deadly caliber in the nation. It switches from year to year, but one of the things about a 22 caliber bullet, it has the kinetic energy to enter your skull, but it doesn't have the kinetic energy to exit your skull. So it bounces around inside you, especially inside your skull, like a pinball. So it actually is extremely deadly, but it's one of those things that through legislation oftentimes gets left off. So let's look at a couple of different types of high capacity magazines. This is I would say the standard, 30 round AR style rifle magazine, the one that we probably see the most of, and the ban was really intended to get rid of. So, that's the common what you're going to see in movies. That's what you're going to see when legislators talk about stuff. Very common. That costs anywhere between $10 to $50, depending on the quality of the magazine. So here you have a 100 round, again, AR style drum magazine. This one is very similar to what was used by the murderer in Las Vegas. They're actually relatively unreliable to use, but they do look mean, and they do carry 100 rounds in there. So if it functions properly, it doesn't have to be reloaded for a long time. And it makes, the AR style rifle is already a very deadly rifle. With high capacity magazines, it makes them even more so. So this is a 50 round Tommy gun drum magazine. This is a magazine that if you're into some of the old gangster movies from the 30s and 40s, this is what was used in the Thompson submachine gun, oftentimes used by, or at least glorified in movies from the gangsters. That's actually very reliable, shoots 45 caliber round. Very expensive to have, but makes the already lethal firearm just absolutely devastating. Here's a Glock pistol. This is a representation of the pistol that was used in the shooting in Tucson, during which Congresswoman Gabby Gifford was shot. And these are high capacity Glock magazines. Those are either 30 or 33 rounds, depending on its configuration. And finally, we have, it was a shotgun tubular magazine. This is a newer model shotgun. That's actually legal even here in California, even though between the two magazines, it holds a total of 20 rounds. However, there is a mechanism that you have to move the magazine into place for it to be able to be operated. So It's considered two 10-round magazines joined together. But as you can see, with the high capacity magazines, it makes firearms even more lethal than they already are. So those are just a few representations of what we're looking at. Okay, so I want to talk about the federal high capacity magazine ban because that helped California out a great deal. And again, it started here in California. So it really started with Senator Dianne Feinstein. It was in response to the Stockton schoolyard shooting, which prompted a great deal of legislation here in California. But it also prompted Senator Feinstein to start pushing towards a federal ban on high capacity magazines and assault weapons. Again, it was signed or went into place back in 1994. It was signed by then President Clinton, and it had a large following, and a lot of political pressure came from California to make that happen. Now, during that time frame, that was the law of the land throughout the nation. However, one of the issues that we have, not only with the federal ban, but we're going to see in the state ban, is there's always called the grandfathering clause, or there has been for quite a while. That means if you had them, you could keep them. You just can't buy or import anymore. So one of the interesting things about this time period is that William Ruger, who is the founder and CEO of Ruger Firearms, one of the biggest firearm manufacturers in the U.S., if not the world, made a statement that no honest man needs more than 10 rounds in any gun. Yes, that is true. But even back then, the gun industry, the NRA, was very, very different than what we see today. Not that they helped pass this federal ban, but they weren't really adamantly opposed to it like we see today. So even people in the firearm industry saw that some of these weapons and some of these accessories to firearms were just not really needed in a modern first world society like we have here in the United States. So California's high capacity magazine ban, it has changed over time. But roughly in 2000, there was no new high capacity magazines. So it took time for California to get certain things in order. There had been a number of cities throughout California that had taken the issue on a little bit earlier. I'm from Southern California, so Los Angeles has always kind of been on the cutting edge of pushing firearm legislation. But what the 2000 law here in California looked at was, if you had high capacity magazines, you could keep them. We could just no longer import them or purchase them here in California. But they're left several major loopholes with that. So one is, there was, we're very close to, obviously we share a border with Arizona and Nevada. They have very few, if any, gun laws there. And, law enforcement really wasn't at the level where they could interdict high capacity magazines coming in from out of state. So we saw a large influx of these magazines coming in from Arizona and Nevada, and we saw a large influx of illegal sales at our gun shows here in California. So 2014, because what we were seeing, especially at the gun shows, were these rebuild kits. And I'll have a picture here for you in a second. But basically, there was a loophole in the law that it didn't really talk about the pieces of the magazine. It just talked about the complete magazine. So our friends on the other side of the fence decided to, well, I guess under the law, if we sold the magazine in pieces, even though if you put it together it'd be a complete magazine, that would not be illegal, and they were correct. So what they were doing is they would sell the magazine in pieces in a bag. So what they first started to do is they would sell it almost in bins, and you would go to each bin to pick the piece that you need, and then they would package it up for you. When law enforcement, specifically DOJ at the time, didn't really do anything about it because we could not, they started just putting them together all in one bag. So essentially, our high capacity magazine ban was halted because you could still buy these magazine rebuild kits. So 2014, with legislation pushed forward by Cal DOJ and Brady, that was banned. So that's really kind of what started a true ban in California when it comes to high capacity magazines. But you still had the ability, if you had it before the ban, you could keep it. So and I'm going to talk more about Prop 63 than the legislation dealing with high capacity magazines, because Prop 63 it's more of the people and by the people. So among other things that Prop 63 did is it just out and out banned high capacity magazines here in California, saying that you can no longer have them unless there's a few exceptions. Military, law enforcement, some other individuals can still keep them because of their job. But as a whole, you could no longer have high capacity magazines here in California. I'm sure Norm's going to talk about the legal issues with that coming up. But the emphasis behind high capacity magazines is, at the same time, we're looking at the new assault weapons ban. And if you don't ban high capacity magazines and assault weapons at the same time, you're really not doing anything. So kind of think, the assault weapons are the gasoline, high capacity magazines are the matches. When you put them together, they're explosive, and you really need to separate them out in order to make things a little bit safer. So when certain individuals, myself included, were helping author parts of Proposition 63, we know, unfortunately, that we won't be able to stop mass shootings. It's very hard to do that, but we can reduce the carnage that is affected by those mass shootings. And high capacity magazines, or the ban of them, is one way to do that. So the Second Amendment fight, and I'm sure that Norm will talk about it a little bit more, but when Justice Scalia changed the meaning of the Second Amendment, 12 years ago or so, by interpreting where a comma should be placed. As you'll see if you read the Second Amendment, it does not mention ammunition or high capacity magazines, because firearms can still function normally without a high capacity magazine. You just won't be able to fire as many rounds. So I know the arguments with Judge Benitez in San Diego, although he believes it's a Second Amendment violation. If he's a true constitutionalist, as he states that he is, it's really not. But again, DOJ is taking that fight on, and I'm sure that in the long run, we'll be successful in that. So why are high capacity magazines effective? Why do these bans work? So talk about a couple of shootings real quick before I turn it over to Norm. In January of 2011, there was a shooting in Tucson. Congresswoman Gabby Gifford, it was at one of her events. She was shot. There were 6 other people murdered and 13 people wounded. The firearm used by that murderer was a Glock 19, and he had a 33-round high-capacity magazine in that. Even though Arizona is a relatively gun-friendly area, and there were people in the audience that were armed, nobody engaged the shooter until he stopped to reload the magazine. And actually, a little side note to that, as one of the individuals who first tackled the shooter was a 70-year-old former colonel in the Army who was shot. But even he waited through his combat experience until the suspect reloaded before he took action. So again, if he would have had a 10-round magazine, people would have been, by theory, able to intercede a little bit earlier. So October 1st, 2017, the Las Vegas shooter murdered 58 people, wounded 413 by gunfire. There was almost 1,000 people injured total, but a little over 400 by gunfire. And he had multiple AR-style rifles with 50 and 100 round high capacity magazines. He also had a bump stock, which is on his firearm, which is a whole other issue. But I think we've all seen or heard the carnage that happened with that, and the combat zone that was Las Vegas because of high capacity magazines. It just made it far more likely to have higher death counts because of high capacity magazines. So let's fast forward to April of last year here in Poway at a synagogue, where a suspect walked in. And he had a Smith & Wesson M&P 15 rifle, which is basically your typical AR-15 style rifle. and he only had the 10-round low capacity magazines. He was still able to murder one person, and 3 other were wounded. But as soon as he stopped to reload, or the firearm malfunctioned during the reload process, several other parishioners there at the synagogue were able to engage him and chase him out of the synagogue, and eventually captured him in his car. So that suspect, even though he was armed with, I think, about 120 rounds of ammunition that was on his body, he only got off 10 shots. So it's one of those issues that you can kind of see that, yes, it's hard to stop these from happening, but we can definitely reduce the carnage that comes with high capacity magazines. And it's not just on these mass shootings. You also have to look at one of the biggest issues for gun deaths is not the mass shootings. Those are horrible and they get the press attention, but it's the day-to-day shootings that happen in our communities that really affect things. And again, if we can reduce the number of shots that are being fired, we can help reduce some of the carnage. We're not going to be able to stop everything, but we can definitely reduce the number of people that are being shot and being killed. So, Norm?
Thank you very much, Steve. And it's my pleasure to be participating in today's first webinar. I will re-echo one comment that our executive director of WAGVA issued, which is this is also our first webinar, and therefore we ask your indulgence for technical issues that may crop up, particularly during my portion of the presentation. I am not as experienced as Steve is on these various items. So if we could go to the next slide, Steve. As Steve covered, there was a 1994 congressional, that is federal, ban on magazines capable of holding more than 10 rounds of ammunition. It expired in 2004, as Steve indicated. Part of that was due to the changing political atmosphere, and particularly the changing emphasis of the National Rifle Association to oppose everything, not just some things. And so the consequence is, if you go and look at the legal status today of large capacity magazines, what you will see and hear is that they're legal unless banned by state or local governments. That's the focus of WAGVA. That's the focus of all of the groups that we work with to make sure that, at least in California, we have effective state bans and or local bans to, as Steve so aptly put it, reduce the carnage. We can't eliminate it, but we can attempt to reduce it. Next slide, please. So the California state law, Steve gave you the provision that define what a large capacity magazine is. Anything, a feeding mechanism that is capable of allowing more than 10 rounds to be fired, essentially without reloading. Some qualifications that us lawyers built in, but that's the core of it. California state law also prohibits a person from manufacturing, importing into state, keeping for sale, offering or exposing for sale such a large capacity magazine. So theoretically, you're not supposed to be able to import it, and you're not supposed to be able to resell it if you have it inside the state. And that is California Penal Code section 32310, about which we will hear more. Next slide, please. Now, the key amendment to California Penal Code section 32310, in what lawyers call subdivision C, because we have to have subdivisions for everything, announced that commencing on July 1, 2017, any person possessing such a large capacity magazine is guilty of an infraction. Notice what the words add. Possession is now part of the ban of this overall statutory section. Next slide, please. How did this come about? Well, it came about initially by legislation, but it also came about through, as Steve described, the November 2016 ballot. Here's the ballot proposition. Recently enacted law will prohibit most individuals from possessing these large capacity magazines. However, there are various individuals who might have been exempt under the state law, so the ballot proposition would essentially expand the state law and allow the ban with very few exemptions or exceptions. That's what Proposition 63 aimed at, and it was passed, as I believe Steve also mentioned, by over 60% of the population. So this is not merely a whim of a few state legislators in a state dominated currently by mostly Democrats. It was a very popular ballot proposition in a year, 2016, that there seemed to be somewhat of a Republican wave, at least in certain parts of the country. So you have to bear that in mind. Next slide, please. The city of LA had a similar ban, but so this LA City Ordinance 183-806 had a sunset provision that effectively repealed itself in July of 2017, the date for the new state law. You saw in the prior slide that the state law was effective beginning July 1, 2017. Prior to that time, LA City had an ordinance governing possession within the city limits of Los Angeles that did the same thing. But one could understand why the city council for the city of Los Angeles might say, well, gee, if there's a state law taking care of this whole effect, why do we need to have this city ordinance? Interestingly enough, the city ordinance cited a series of examples, largely mass shootings, but not conclusively just mass shootings. One of the examples I'd like to mention is the shooting at the North Valley Jewish Community Center in Granada Hills on August 10, 1999, almost now some 21 years ago, where a shooter armed with an Uzi-type submachine gun and semi-automatic pistol fired 70 shots into the lobby of the community center, wounding 5 people. Ladies and gentlemen, this gets personal to the organization that I belong to, Women Against Gun Violence. Two of the victims are represented on the WAGVA board today. One of the victims was a 6-year-old boy at the time, Josh Stepakov. He was shot in this indiscriminate round of firing by a large capacity magazine. Another board member, Donna Finkelstein, her daughter was a teenage counselor at the time of this indiscriminate, again, spraying of bullets by someone who turned out to be a white supremacist racist. This is just one example, but it was an example cited in the LA City Ordinance of how such things happened in Los Angeles itself. Now we shift to the next slide, if we could, Steve. And the gun lobby filing suits challenging the Proposition 63 and the related state legislation before Proposition 63 as a violation of the Second Amendment. Very interesting what happened. The gun lobby chose where it filed its lawsuit. It did not file its lawsuit in the city of Los Angeles, which is in the Central District of California. It also did not file its lawsuit in the Northern District, which sits principally in San Francisco. No, our friends at the gun lobby have astute lawyers. They filed one lawsuit in the Eastern District of California, which includes Sacramento, where the court is headquartered, and a large part of the inland and north sort of Cow County area, a more conservative area, they thought. The judge in the Eastern District of California dismissed this lawsuit almost out of hand, effectively saying, wait a second, folks, this is subject to judicial review under something called intermediate scrutiny. It passes muster under that. The people of the state of California had a basis to fear what might impact them if large capacity magazines were possessed by people within the state. It passes muster. And the NRA chose not to challenge that decision by a district judge before the Ninth Circuit. Instead, they preferred a second lawsuit filed in the federal district court in the Southern District of California, which is the San Diego area. And they found a judge, Steve has mentioned his name, Judge Benitez, who was relatively sympathetic with the arguments that were made at that time. Could we go to the next slide? And before we get to the next slide, I just wanted to go back for a moment to the North Valley Jewish Community Center shooting. This is from Los Angeles Times. It's a partial clip of a newspaper article. Gunman shoots 5 at day camp. 3 children, teen and adult, are wounded. This is real. This is what happened. This was part of the background that the people in the state of California considered. If you go to the very bottom and you want to see the history of this gun, you can take the hyperlink, look it up, and you'll find that the gun manufacturer could say it was sold to someone initially as a retail shop in the Midwest, but couldn't go beyond that because he wasn't willing to divulge the name of the retail shop. How it got into this person's hand, and by the way, this person was not supposed to have these types of firearms because of a prior conviction. So how it got to him, but what we do know is it was in his possession at the time. Now, if we could go one slide forward, Steve. Sorry, one slide back. There we go. Duncan versus Becerra. This is the name of the case filed in San Diego federal court, and which the judge enjoined both the state legislation and Proposition 63. And let me give you the flavor of how he came to do this. He noted in his opinion on page 2 out of a 70-page opinion, quote, when 3 armed intruders carrying what looked like semi-automatic pistols broke in, Fen Shu Chen, dressed in pajamas, held a phone in one hand and took her pistol in the other and began shooting. She had no place to carry an extra magazine and no way to reload because her left hand held the phone. Judge Benitez was sympathetic. She could have used a large capacity magazine if only she'd had one to keep firing at these intruders. What's very interesting from a legal standpoint, Judge Benitez found this example on his own. He says, at his opinion, the news account he's citing here was, quote, not in the party's exhibits, but it's illustrative. Ladies and gentlemen, when a judge reaches out to grab an example that isn't in either side's exhibits, you know that he is really searching to find additional evidence. I've given you the examples that he used. He used many of these examples as a way to proceed. Next slide, please. The California Attorney General, who was representing all of the citizens of the state, appealed to the Ninth Circuit. They got a conservative panel of the Ninth Circuit. Argument was held via remote video argument. on April 2nd, 2020. So less than a month ago, this very issue was front and center in front of two justices from the Ninth Circuit, Justices Callahan and Lee, and a third judge sitting by designation from the Northern District of Texas, Judge Lynn. Next slide, please. How did the argument go? Well, it didn't go well for the state. And the first minute and 30 seconds, Justice Callahan broke in and suggested that since the California statute 32310 of the Penal Code seemed to impose an absolute ban, why shouldn't it be subject to strict scrutiny? And for those of you who aren't lawyers, often when a judge decides how they're going to rule, they ratchet up or they ratchet down the level of review. Strict scrutiny in constitutional terms is close to a death sentence. If the justices choose strict scrutiny, you don't need to be a scientist to figure out what the result is going to be. Many people have argued for intermediate level of scrutiny, as was found appropriate in other large capacity magazines, but I do not believe that that is going to be the result based on at least the tone and tenor of the oral argument. Could we go to the next slide, please? The take-home messages. It isn't over until the fat lady sings. In today's world of lawyers and litigation, even a statewide proposition approved by over 60% of the voters is not necessarily secure from a constitutional challenge in that same state. The second take-home message for all those who are listening is that a strong and continued fight by Women Against Gun Violence, Brady, and other like-minded organizations is necessary to rein in the use of weapons designed for war, not self-defense. If you read about these types of large capacity magazines, their history and how they came about, they were war weapons. AR-15, as Steve referenced, stands for Assault Rifle 15. It was a term used in the Vietnam War and prior, but it was an assault rifle. It was for the infantry. It was not for an individual citizen sitting there. With that, I think we are ready to go to the question period.
Right now, I encourage you all to submit any questions you may have. We'll wait a few minutes to give you some time to enter your questions. We'll just wait one more moment. Let's see. We have one question. What will be the timeline of the strict scrutiny?
The Ninth Circuit does not have a legal deadline from which to issue an opinion. There are rules of thumb that lawyers use, saying it could be 6 months, it could be 9 months from the date of the hearing that the matter is submitted, but those are only rough rules of thumb. We do not have a fixed deadline on which the Ninth Circuit will rule. I'd like to add one other point. Even if this panel were to rule one way, it is quite likely that there would be, by the losing side, whether that be the state of California or the gun advocate group, an appeal to the entire Ninth Circuit, which could take yet more time. Thank you.
And so here's another question, and actually I had the same question. So in the meantime, what is the status of the ban?
The ban is enjoined. The California rule against possession of large capacity magazines is legally ineffective until it might be overturned by the Ninth Circuit. But at this point, the ban on large capacity magazines is not legally effective, given Judge Benitez's ruling.
Okay, so somebody said, so what is still enforceable with regards to large capacity magazines? What can we still prosecute?
Well, the first part of the law that prohibited sale, importation, or resale of large capacity magazines is, I believe, still in effect. So if the police were, for example, to find that there was a gun store in California importing such magazines, then they could take action. But I'm going to ask Steve to comment on all the various ways one could get something into the state of California without triggering, for example, police scrutiny.
So yes, I mean, obviously we still share borders with other states that have no restrictions on high capacity magazines. So their flow from Arizona and Nevada is still happening. And if there is any interdiction of that, the penalties are relatively low for what you can actually be making by bringing those firearm or those magazines in. So realistically right now, you can still possess them. You just can't sell them. You just can't import them. You can't give them away. But what you have, you can keep until the larger issue is, answered by, either the Ninth Circuit Court of Appeals or probably ultimately the Supreme Court, because I don't see either party stopping this process until it ends up back in Washington.
Okay, so somebody has mentioned that the AR in AR-15 stands for Armalite rifle rather than assault rifle. And I had actually heard that as well. Steve, or?
That is correct. It was the Armalite company by Mr. I'll mispronounce his name, so I won't even say it. But the rights to that firearm was sold to the Colt manufacturing company, who makes the Colt AR-15 and the Colt M16. And since then, after the patent has lapsed, I believe sometime in the 70s, a lot of different manufacturers make them. Right now, Colt, who has had the original patent, doesn't sell their M16s, M4s, or AR-15s to the civilian market. They just sell to military and to law enforcement.
Okay, well, that looks like the end to the questions that we've received. You can still send us more questions to our email address at wagv@wagv.org. We have recorded this webinar, and we will be sending you the link and the slideshow later this week. Oh, wait, I see one more question, so let's address that because we still have some time. The question is the court looking at any restrictions on capacity, or can California now have as large a magazine as anyone wants?
The argument seemed to center on whether one could, in conformity with the Second Amendment, limit a large capacity magazine greater than 10. Certainly, there was no argument about, well, maybe California should have drawn the line at a 50 round or 100 round. I suppose that could come out of the opinion, but the focus of the argument was, did the state of California have sufficient legal justification for banning anything over 10?
Okay. So once again, if you need clarification or have additional questions, please go ahead and email us, and we'll be sending you a follow-up link and materials. And I just want to thank Norm and Steve and Mary once again for giving us this excellent information and its timeliness. And